walk through that, and I think you have a copy of that, is Assemblymember Spitzer. Don?
Thank you very much. Thanks, Senator. You know, here's a copy of AB 900, and it was signed by the governor of May 3rd, 2007. And I've been scratching my head. I think most of you know I've been at the negotiation table for the last 8.5 months, trying to determine whether or not we were going to be able to reach a settlement. 30 days ago, I stood in front of the 3-judge panel in San Francisco and asked them for an extension of 30 days because I was confident that we were going to be able to get an agreement short of early release of prisoners. The gentleman standing here and a lot of our colleagues in the legislature, frankly on both sides of the aisle, said that their commitment was to avoid early release. But I have to tell you, when this bill was signed more than a year ago, you have to ask yourself this question: why hasn't the state of California built one new bed since this was authorized more than a year ago? And in my opinion, what we're seeing today, and why I think this legislation is so important, because we know there's a crisis that's already here, and it's called the early release of prisoners. But unfortunately, I don't feel that the legislature understands that there is a crisis, and it's about to happen. And the 3-judge panel, I'm telling you right now, from my perspective on the record, that the 3-judge panel in San Francisco is going to order the early release of prisoners. They will establish a cap. The state of California will lose. And unless the legislature and the administration and the Attorney General start to discuss this issue seriously, and that's why this legislation is being introduced, we will have the early release of prisoners in the state of California. And so after 8.5 months of discussion and negotiation, you would think that the legislature would have responded, and they haven't. And it is a crisis, but apparently no one seems to feel it is a crisis. And so that's the message today. The agreement, the legislative interveners, if you recall, we intervened. We were denied intervention status originally in the lawsuit. We took that issue to the 9th District Court of Appeal. And before they decided, the 3-judge panel reversed their decision and allowed us to intervene. We joined the district attorneys, probation, chiefs and sheriffs, and other law enforcement representatives to try to make sure our views were told. We came to the table and we issued a document to the court and to the referees, and now to you, the public, indicating what we are willing to support. If we get what we need, the receiver beds, the AB 900 beds, so we have reentry, infill, and rehabilitation programs, we will be able to reduce the prison population in a responsible, significant way that does not jeopardize public safety. Without an AB 900 fix, we are on our way to early release of prisoners in California. And to us, that's not just unacceptable, it's completely intolerable. So the question for me today is, when is the legislature going to wake up and start to discuss the issue of early release of prisoners and whether or not we're committed to stop that from happening in California?
Thank you. We'll open it up for questions now, if you have any.
Could somebody explain kind of in simple terms what SB 1705 is going to do to remove these obstacles you're talking about, and what's the substance of it?
You want to go ahead and
you kind of hit the 3 main points, but
That's all it does. I mean, it's pretty simple. I mean,
the language in 1665.
yeah, you got you're talking about our 1705.
yeah.
It's those 3 points, and you've got it in front of you. All it does is it corrects the language that the administration says they needed corrected in order for those bonds to be sold. That's 1 point. That's all it does. The point is a flexible Department of Corrections in terms of the naming and building the kinds of beds they believe they need, as opposed to what is in the original legislation, which is a lower level bed. It lets them decide that. And it specifically takes the language that's in the receiver's bill in order to expedite the construction process, in order for us to build that same way with the beds that are in AB 900, in order to help us meet the goals and the objectives of getting those cells built as fast as possible. That's all it does.
Can I clarify? I want to clarify something. I want to clarify the AB 900 language. For the record, the Attorney General has refused to issue a bond opinion from the bond oversight in the Attorney General's office. that would allow the state of California to go to Wall Street to sell the bonds under AB 900. And it's been very frustrating for me in over a year that no one decided to tell the legislature that they had a problem with the bonds. That's very difficult and offensive to those of us who support AB 900, that neither the Attorney General nor the administration came forward to tell the legislature that they had problems with the bond language and that AB 900 was not constructed properly to issue a clean bond opinion. Even as we stand here today, the language in 1705 still is going to take some additional tweaks. We just learned, again, within the last few days, that the Attorney General is still not happy with the language that the administration submitted to the budget committees on the AB 900 cleanup. So you have to shake your head and say to yourself, who is running this construction ship in California in terms of we have a legislative commitment to build beds, and we haven't been able to get the legal authority to build those beds? Somebody needs to step up and start taking responsibility. And those two parties right now are the Attorney General and the administration.
Assemblyman Spitzer, a question for you, sir. You're talking today about public safety and your concern over the potential early release of prisoners. And you also have a tough on crime measure coming up on the November ballot, Marsy's Law, which addresses some of those concerns. But ironically, one of the key benefactors for that is in fact now facing drug charges, conspiracy drug charges. Does that undermine your argument in any way? Do you find anything ironic in that at all?
Well, I need to question the premise of your question. You said the underwriter, the primary underwriter to get it qualified, Marsy's Law, whose sister was murdered, by the way, and is a legitimate crime victim, is now facing federal charges, both drug and backdating charges. And so, but even if Marsy's Law were to pass, there's nothing Dr. Nicholas would benefit from in any way whatsoever. It's a crime victims initiative to give crime victims greater rights as the court case goes through the process from the time of the arrest until the conviction, appeal, and parole. So Dr. Nicholas, in his sister's murder, or him personally, don't benefit in any way whatsoever. And secondly, Marsy's killer recently died in prison after the last parole hearing. So even if you could argue there were greater rights extended to parole hearings under Marsy's Law, since he's now deceased, there will be no more hearings for him.
And I understand that, but it's a tough on crime measure, and it is on the ballot primarily because of a person who's now ironically facing drug conspiracy charges.
All I can tell you is that clearly he underwrote that. We did, Prop 66, which was a 3 strikes. Dr. Nicholas has been involved in these issues for a long time. What's happened to him in terms of these other issues that you've articulated, are unfortunate. He's going to have to face those. He's going to have to face those. He's been indicted. He's going to have to deal with that. But that has nothing to do with, one, our prison overcrowding issue that we're here today, and two, it has nothing to do with Marsy's Law.
Can I go back to AB 900 for a moment? I'm assuming that, without looking at the roll call, most of you voted for AB 900. So what's changed since AB 900? What did you not know then? Because I guess what you're saying is you didn't know something then that has to be modified. Otherwise, you voted for a bill that doesn't work. So.
Right. We voted for a bill that, at that time, we were told the language was correct in order for those bonds to be sold. So, that's how, so we voted assuming that then the construction would move forward. And so that becomes the major issue. And then the other added issues are just, like any piece of legislation that we may vote on one year, things change in that process from one year to the other. And so, such as the bed counts and those kind of issues. So those are more adjustments that have related. But, when everybody voted for it, everybody assumed that it was written correctly and that those bonds would be able to be sold.